interesting story. I've heard a lot of talk about whether the gate was open, whether the gate was closed, whether the dog is dangerous or not. But one thing we have heard throughout the entirety of today's trial is a story doesn't really seem to make a whole lot of sense. Doesn't really add up. Now, this case really boils down to two simple issues. Whether my client, Mr. Ibsen, knew that Chowser knew before June 2006 that his dog Chowser was an obviously dangerous animal, and whether the plaintiff on June 6, 2010 acted as a reasonable person. Examining the evidence, the answer to both of these questions is emphatically no. The only thing we know for certain is that the plaintiff's story makes absolutely no sense. The plaintiff should have known there was a dog. Why? Because this was her route every day. She knew who the dogs were. She knew that the dogs would be in the backyard. And additionally, as we heard numerous witnesses testify, a chain link fence, you can pretty much see everything in the backyard. If the dogs were there, she would have known before she entered the backyard. She saw the warning sign in the front, this warning sign that said, "Beware of dog." So she went to the front of the house and rang the bell, waited 10, 15 seconds, a bit, before she cavalierly entered the backyard at her own risk. And that's really what we need to identify, her own risk. The dogs were in the backyard, but Mr. Ibsen had absolutely no reason to believe, based on his personal history with the dog and his prior knowledge, that this dog would pose a danger to anyone. The plaintiffs put on their case, you've heard their evidence, and the plaintiff's case just doesn't make a whole lot of sense. They're trying to tell you that through this gate and out the other, a hose was stretched, preventing the gates from being closed. Yet their own witness testified that the sprocket to the hose was in the front of the house. That hose wouldn't need to be dragged through that gate. Not only that, Becky and Race testified to the same. All three of them live at the house. The plaintiff doesn't. She even testified on direct examination that she's not really sure about the layout of the house. She's not really familiar about where the things are in the house. Who would be familiar? The residents. That hose wasn't in that gate. That gate was closed. Now, the plaintiffs contend that the only person that saw that gate that day, the only person that's 100% sure, had to be the plaintiff. The only person that's suing for damages is also the plaintiff. Of course, it's in her best interest to say that the gate was closed. However, even if it were closed, it's a chain link fence. She can see into the backyard. She should have been aware that the dogs were there. In fact, she was. She said she saw Queenie, but didn't think twice about it, proceeded into the backyard anyway. And that's when I direct your attention to 9702. Dangerous animals. Before entering an enclosed yard or yard posted with "Beware of dog" or other warning signs, city personnel should, whenever practicable, first contact the owner and wait until the animal is under control before entering the premises. My co-counsel asked on cross-examination, would it have been practicable for you to wait, knowing that there was a car in the driveway and you heard a shower running, to wait and see if someone would answer the door before you proceeded into the backyard? She said no. When pressed and given the definition of the word practicable, she said that she was incapable of doing her job according to city ordinance. And then plaintiff's counsel comes up here and tells you, and I quote, "City ordinances aren't mandatory. The plaintiff wants to play fast and loose with the facts and fast and loose with the law so long as their client gets her money." Really, this case boils down to what's most convenient for the plaintiff. It was more convenient for the plaintiff to go into this backyard, check this meter at any cost because it was a Friday. At the end of a long week, she was done. She didn't want to keep working. We've all been there. I understand that. I've had long Fridays. But she neglected her duty as a city official, threw caution to the wind, ignored the fence, ignored the sign, failed to talk to the owner, violated the ordinance, and proceeded at her own risk, just because it would have been more convenient. And now plaintiff's counsel tells you, well, city ordinances aren't mandatory. You don't need to really pay any attention to those. They're trying to play fast and loose with the facts and fast and loose with the law. You heard Mr. Minister testify today about Chowser. We heard today that Mr. Minister wanted to get rid of the dog. So he sold it to his roommate, Mr. Ibsen. He testified on direct examination this dog was so inherently dangerous and so vicious, he was so scared of him that he sold him down the hall. Must have been pretty brave. The fact is, Mr. Minister didn't want to get sued by Meter Reader. He didn't want to have any responsibility for the dog after any of the incidents that they allege occurred. Remember, Mr. Minister never witnessed any of these events. He never saw anything. All he knows is what he heard. And what we've heard about those instances is that they were blown way out of proportion. The mailman even told the defendant that he grossly overreacted, that he shouldn't have acted that way.
Objection, hearsay.
Goes to its effect on the listener. It's already been admitted.
Continue.
Mr. Menester simply didn't want the responsibility of a dog. He was only here to testify against Mr. Ipsa after he had been dropped as a defendant in this suit. There's a 5-year statute of limitations on this action. Mr. Menester knows that. He also knows that he's the property owner. Probably in his best interest to testify for the plaintiff, so she doesn't bring this suit against the property owner if she doesn't come out victorious today. The most important evidence you heard today, far and away, came from the plaintiff. It came from her own mouth. You heard the plaintiff say she knew of the Beware of Dogs sign. It was hanging in the front oak tree in front of Mr. Ipsa's home. She knew the dogs were in the yard, but chose to proceed anyway because, and I quote, she had never seen Chowser act up before. If she had never seen him act up before, she had absolutely no reason to fear. But she proceeded anyway. Most importantly, she knew that she was supposed to wait and contact the owners of the home before and make sure the dogs were put away before the meter was read to ensure everyone's safety. She was aware of the city ordinance. She violated the city ordinance. She chose to proceed on her own because it was the most convenient thing for her. She ignored the fact there was a car in the driveway, ignored the fact that someone was in the shower, ignored the fact that the gate was closed, opened it, walked into the back, and was attacked by a territorial dog. Not an obviously dangerous dog, not a vicious dog, but a territorial dog. Today you heard from Becky Giles, the defendant's girlfriend. Becky told you she was home when the plaintiff came to read the meter. She told you that the plaintiff knocked but didn't bother to wait, waited probably 10-15 seconds before she just traipsed into the backyard as if it were her own home. Now we're not contending she was a trespasser. We're only contending that a reasonable person should have been aware that there were dogs in the backyard, should have been aware of her duty as a city official to follow city ordinance, and that this plaintiff chose to ignore all those things. Most importantly, Becky told you that she never had any reason to fear Chowser. Chowser was her companion. Chowser was her friend. She loved that dog, and that dog loved her. And that dog had never hurt her. You also heard from the defendant, Mr. Ipsa. He told you didn't believe Chowser was a dangerous dog, described the dog as playful, as companion. He pointed out the dog would never hurt anyone unless provoked. And he talked about 2 instances. He talked about the incident in 2004 in which the mailman was a little bit spooked because the dog had came after him after the mailman came on the property. And he talked to you about an incident in 2005 in which a boy who was egging the house, throwing eggs towards the dog and the house, was attacked by the dog. Neither of these things, to any of us, if we think logically about it, seem inherently vicious. They seem like a dog protecting its territory. They seem like a dog responding. Poke a dog with a stick, it's going to bite. You throw something at a dog maliciously, it probably is going to come after you. And that's given with any dog. The plaintiff is asking for a lot in damages, mostly because they know Mr. Ipsa has a lot. Remember, she has no outstanding medical debt. Her medical bills have been paid. She didn't lose her job. She didn't lose her benefits. She didn't lose her retirement. She's not suffered the significant monetary loss she would have you believe that she has suffered. Now, I feel for the plaintiff. I understand. My client was injured as well. People have suffered serious injuries today, but the burden is on the plaintiff to prove to you by the greater weight of the evidence that these damages were caused by Mr. Ipsa, that he knew before 2006 that this dog was, and I'm quoting, obviously dangerous. Now, what does obviously dangerous mean? It means that it can be perceived by anyone who sees the dog. And we asked West, Becky, and Race, all, on cross or direct examinations, did you ever have any reason to fear the dog? All of them answered no. When I asked Mr. Ipsa on direct examination, have you ever, or anyone you know personally, anyone that's lived with a dog, ever been attacked by this dog? No. He'd never been told by anyone that this dog was dangerous. Ever. It wasn't obvious. It was lying in wait. A territorial dog that attacked what it perceived as an intruder. Not an obviously dangerous animal. My client is not liable for these damages. In order to prove that he is liable, the plaintiff must have shown that Mr. Ipsa knew or should have known Chowser's dangerous propensities. None of the witnesses who lived with the dog ever had been harmed. None of them had any reason to believe the dog would harm them. They felt safe. This dog was obviously dangerous. Why did everyone feel safe around him? This dog was obviously dangerous. Why hadn't it gone after anyone in the past 5 years? Why was it hiding in the garage on Halloween away from all the passerbys? This dog was not obviously dangerous. Liability, on the other hand, rests with the plaintiff. The plaintiff voluntarily and unnecessarily exposed herself to the risk encounter of Chowser. She violated city ordinance, ignored the warning sign outside the house, and proceeded anyway. The plaintiff would have you believe that this dog is vicious and it attacked her. But in the past 5 years, this dog has not attacked anyone. The plaintiff's trying to claim the dog is vicious, yet she told you today that she made it a point to get to know all the bad dogs on her route. She told you she never once saw Chowser act up before. She knew there was this city ordinance that required her to contact the owner, and she ignored
Counsel,
it.
you could sum up your overtime.
This case is simple. It's about failing to take responsibility. It's about failing to act as a reasonable person, and it's about a person, the plaintiff, who wants you to reward her for her failure to act reasonably, for her inability to do what she perceived as inconvenient.
Thank you, counsel.